Okay, it's about 10:04, so I'm going to go ahead and get started. And if there are others that are coming, they can just jump right in. So we will be talking about the buyer side today. We'll be discussing buyer forms, agency forms, and things that are required by our particular market center. So we'll be going over that. Before I get into that, again, I want to say welcome and thank you so much for attending. I am going to attempt, it's going to be hard for me because I love this. I'm going to attempt to be done by 11:30 because guess what? It's Tuesday. It's the third Tuesday of the month, so we're having team meeting. So I want to make sure that I am off the Zoom account and they can get on and we are good to go there. So if you have time after we're done here, come on to team meeting so we can learn what our market center has done for the previous month. All right. Any questions or expectations for today, or any comments, anything that you would like covered as we're discussing buyers, but it doesn't have to be about this particular category. Any questions about anything at all? I want to make sure we get those answered here in boot camp. Plus, it's going to help me know what things need to be covered. So any feedback you have at all, of course, at the end is great. Okay. I'm just responding to a question in the chat here, so bear with me 1 second. All right. So if no questions or any expectations or anything, we'll go ahead and jump right in. All right, so we're talking about buyers today, and then I'll go ahead and share my screen so we can see what we will be covering today. All right. Can you all see the buyer agency slide there? Awesome, terrific. Okay, so today we're going to be covering buyer agency and talking about some things on the buyer side. So we reviewed Working with Real Estate Agents yesterday, the brochure and the disclosure. However, we looked at it from a seller standpoint. We will now, we want to talk about it from a buying standpoint. We also want to, or we will be covering the exclusive buyer agency agreement and the heritage title disclosure, something that our market center requires. And we'll talk about that. It used to be just one form, but now they've split it up into two. So now there's a disclosure and a selection form. So two forms, and we'll take a look at those. All right, so as we're looking at working with real estate agents, and please forgive me, or the technology, I tried so hard numerous times to log into DocuSign this morning, and for some reason, DocuSign is not letting me in. I don't know if anyone else has attempted to log into Command and DocuSign.
Yeah, an email was sent out.
Oh, was it? I missed
Mhm.
It's down.
Okay.
Email. The rooms are down.
Gotcha.
If you're trying to get into a room, there's something wrong with the room.
Gotcha. Thank you. All right. Getting ready for boot camp. I missed the email, so thank you very much. All right. Okay. Thank you all for that. Terrific, terrific, terrific. Okay, so I'm like, is it me? What am I doing? What didn't I do? How did I mess it up? So thank you all for confirming that with me. So we'll just talk about the Working Real Estate Agents brochure because that is the one I did not download, complete it. So we'll talk about it. You've seen it. You know, there are new forms or new disclosure, new brochure as of July 1st of this year. So we had to start using it by then. So with the Working Real Estate Agents, there's a question and answer brochure, which I think is absolutely wonderful. The commission did an excellent job with updating that brochure. It's very easy to read, easy to understand, easy for clients to understand, and it helps us explain things a lot better. So that brochure is available, and it even describes the different types of agencies. Love it. Now, that Working Real Estate Agents disclosure for buyers, there are several options there. Of course, there's typical buyer agency. And what we are to do when we complete that form, we're to check all that could possibly apply. Check all of the boxes that could apply to that particular situation. So of course, typical standard buyer agency where you, the agent, is just representing the buyer. Then there's dual and designated agency. And of course, dual agency, because we're such a large firm, of course, that can definitely apply and does apply quite a bit, where our market center has the listing and the buyer. So dual agency is bound to occur, especially if you're working in our market center. The other thing is with dual agency is designated dual. We'll talk about that in the policies and procedures Bootcamp day, which is day 4, which is Thursday. That will be covered. What we want and what we like to see as a market center is that every agent is designated to their particular client. So on that Working Real Estate Agents disclosure, you would check buyer agency, dual agency, and designated agency. So if dual agency arise and it involves another agent in our market center, then our goal and intent is for each agent to be designated to their client specifically. And then there's a category for unrepresented buyer. This may not, especially as it relates to buyer's agency, that unrepresented buyer would come into play if a buyer comes to the market center or to you as a listing agent and they do not choose or elect to have representation, and then they would be an unrepresented buyer in that particular case. Now, I do want to talk about buyer agency, although oral buyer agency, although it is not on the Working with Real Estate Agents brochure. Oral buyer agency is a thing and it is allowed by the North Carolina Real Estate Commission, although it may not be a best practice to do. So, although we are to disclose buyers at first substantial contact, which means the moment they start to share personal, confidential, and motivating information, we are to stop them and what I call Mirandize them. Anything you say can and will be used against you until we agree to buyer agency. You agree to have me represent you, and you understand I first seek compensation from the seller. However, if the seller doesn't pay, we seek compensation from you, the buyer. So when they start to disclose or share that type of information, you stop them. Now, with oral buyer agency, they are to orally or verbally agree to buyer agency, although buyer agency isn't in writing and the commission allows it. Now, under oral buyer agency, it's not exclusive. I just want to make sure we understand that. If you explain buyer agency, they do not agree to sign at the time a formal exclusive written agency, then it's okay. You can still work with them, but it's non-exclusive, which means they can go and do this with 10 other agents. and there's no guarantee you're going to get paid. Of course, it has to be reduced to writing if the buyer decides to make an offer. So oral buyer agency is allowed. However, it's probably not best practice to do. But I just wanted to make sure we covered that because it is okay to do. With listings, oral is never okay. It always has to be in writing, okay? All right, so moving on. Any questions there or any comments? Okay, all right. Moving on to the exclusive buyer agency agreement. There are several things I want to make sure we do cover and I want to hit. This one I did download, so I have that that I'll put on the screen, and we will go through the buyer agency agreement and highlight what we like to see in the blanks, and filling in the blanks on the agency agreement as a firm, as part of our policies and procedures. So the things that we will cover, definitely want to make sure that we are aware, and sometimes it helps us make decisions if we understand that every individual agent is a general agent of the firm. All of you, all of us who are agents of the market center are general agents of the firm, which means we have the ability to bind the firm to agency agreements. Once we bind the firm as the agent to a client, we are now special agents to our clients, which means we have limited capacity in what we can do. We cannot bind them to anything, we just merely represent them, okay? All right, so the things I wanna make sure we cover is that the agency agreement is between the firm and the client. All agents will be representatives of the firm. I want to make sure we cover the terms of agreement and the dates, making sure we have those, because if not, the agency agreement is invalid. It's not a valid agency agreement. We will discuss, of course, compensation of the firm, how the firm is compensated, when it's due and when it's earned, and who we seek to first obtain compensation from. We also want to hit and make sure we share with our clients, buyer clients, that there are other potential buyers for the same properties they are looking at, that they're interested in. And our firm has other buyers as well. We'll discuss the firm's duties. Other professional advice, we're not attorneys or inspectors, so we are to refer them out to those folks if they so need that type of work done. We'll talk about confidentiality of offers and dual and designated agency. Okay, so with that said, let me stop sharing here and bring up the buyer agency agreement. Here. All right. Okay. Hopefully you all can see the screen there. All right, so let's talk about this exclusive buyer agency agreement. Of course, when we begin this agreement, we are going to put the date that the agreement is entered into. So of course, the date will go there, and we will have the buyers' names there. All buyers, the ones who are either obtaining the loan or providing the cash, or whoever the buyer is, we're going to make sure we put all names there. Then we need to put in the firm's name. We talked about yesterday that if you as an individual agent has created a firm and and you have a separate firm license, then and you're marketing and not only just receiving compensation, but you're marketing your firm name, then that name will go on this blank as well. And as an example, where you see Keller Williams Central here, for me personally, I do have a separate firm name, firm license. And so in this blank, it would be Keller Williams Central / Teresa Knows Real Estate. Okay, so if ever you are in, great, DocuSign is back up. Yay. Thank you for that. All right. So if you desire to have a separate firm to where you are dually affiliated with Keller Williams Central and your own firm, that firm name needs to go in that blank. Okay. Moving on to paragraph 1, where it discusses type of property. Here is where we will put in what our buyer client is looking for, whether it's residential, improved or unimproved, that means land or there's an actual dwelling on it, or if it's commercial or something else they're looking for, where we are to notate that there. The general location, we'll put that in, whether it's Orange County, Alamance County, whatever county that is. They're looking, we put that in that blank. And any other type of property or location that they're looking for. So maybe they're generally looking for Orange County, however, they are open to the triangle. And if that's the case, then in that other blank, triangle area could go there. All right. Paragraph 2, effect of agreement. It just says buyer intends to acquire real property described above, and the client is employing the firm to act as their buyer's agent. Okay. What I like about this is what they've added, and it says buyer agrees to conduct all negotiations for such property through the firm and to refer to firm all inquiries received in any form from other real estate firms, prospective sellers, or any other source during the time this agreement is in effect. I really want to point this out because I've seen this happen over the last few months where buyers were not clear on what they signed when they signed this exclusive buyer agency agreement. We've had several situations where our agent had buyer agency with the client, but the client went and signed another buyer agency with another firm. We need to make sure as buyers agents, we are educating our buyers and to let them know, if you go somewhere to an open house, I prefer you not go without me, but if our schedules don't mesh, then you need to let them know you have an agent, okay? And let me back up from paragraph 2 and just go to the bold print here under the blue box here. I want to point this out because it's very important, and it says buyer represents that as of the commencement date of this agreement, the buyer is not a party to a buyer representation agreement with any other real estate firm. The buyer acknowledges that they've received the Working with Real Estate Agents brochure, and it's been reviewed with them. It goes on to say that buyer further represents that buyer has disclosed to firm information about any properties of the type described in the paragraph 1, that buyer has visited at any open houses, or that buyer has been shown by any other real estate firm. We need to make sure our clients are aware of that paragraph and aware of paragraph 2, because I've seen it happen. And we've had agents to actually lose money because they went out and done something with another agent, even though they had a signed buyer agency agreement. So beware of that and make sure your clients understand. All right, paragraph 3, term of agreement. And of course, the agreement starts on a specific date. We gotta have a specific date in there. And also there are now 2 boxes as of, I think they started this in 2020, that if the buyer is looking to acquire a single property, we check that box. Or if the buyer is intending to purchase more than one property, maybe it's an investor, then we are to check that box. Either way, either one the buyer chooses, we need to make sure we have an exact definite end date in those blanks. Okay, so make sure, and I know technology is great and technology works when it works. However, we just saw this morning we had some issues with DocuSign. There were some technology issues. There have been cases where technology wasn't working. An agent put a date in, however, when it was saved or whatever the issue was, the date wasn't saved. So when it was provided to the buyer, there was no date in it, and there came an issue. And technically, the agency agreement is not valid without a definite end date. If there is no definite end date, it speaks back to oral buyer agency, and it's potentially non-exclusive. So we just want to make sure that even though technology is great, it's not always stable. So just going back and checking our forms to make sure dates and information is still there once we save it, okay? Any questions, comments, or anything before we move on? Okay, moving on to paragraph 4, compensation of the firm. It's gonna be, when it comes to 4A here, it's gonna be up to you and how you run your business on whether or not you charge a retainer fee. I know some agents who do it successfully, and then there are some who do not charge a retainer fee. However you choose to do your business, if you do charge a retainer fee, just put that amount in, and you need to also notate whether it's going to be credited or not to the buyer, okay? So it's going to be up to you how you run your business. Excuse me. 4B speaks to what the firm expects to receive or what the firm is charging. You are charging your client. And so part of our policy is that we expect 6% total on the listing side and 3% as a buyer's agent. That can change, and we'll talk about that more in Policies and Procedures Day on Thursday. However, typical 3% of the contract sales price. So whatever that is, then the firm expects 3%, okay? And that goes in that blank. All right, 4B, 4B1 goes on to say that the firm will seek the fee from a cooperating firm or the seller. If the cooperating firm or seller is offering commission, we will first seek compensation from them. Okay, so 4B2 goes on to say if buyer purchase a property where the compensation offered by the listing firm or seller is less than the fee that we're charging, or where no compensation is being offered by the firm or the seller, that the buyer and the firm agree that the buyer will pay the difference between the fee and the compensation offered unless it's prohibited by law, okay? If that is the case, if there's a reduced commission or no commission offered at all, then as a firm and as an agent, we are supposed to let the buyer know in a timely manner, okay? All right, 4B3 goes on to say if there's any additional compensation offered, we are to let the buyer know, okay? As soon as possible, but it definitely has to be known prior to the offer being written. So any additional compensation, we have to make the buyer aware. Okay. 4C talks about the compensation being deemed earned under the following circumstances. So C1 says that if during the term of this agreement, buyer or any assignee of the buyer or any person or legal entity acting on behalf of the buyer directly or indirectly enters into an agreement to purchase, option, and or exchange any property of the type described above, regardless of the manner in which the buyer was introduced to the property, compensation is deemed earned. C2 goes on to say, if within X number of days, whatever amount of days you choose to put in there, here we chose 30. If within 30 days after expiration of this agreement, which is called the protection period, if the buyer enters into a contract to acquire property introduced to the buyer during the term of this agreement by the firm or any third party, unless the buyer has entered into a valid buyer agency agreement with another real estate firm, it is deemed earned. Commission is deemed earned, okay? C3 goes on to say, if having entered into an enforceable contract to acquire property during the term of this agreement, buyer defaults under the terms of that contract, compensation is still deemed earned, okay? So make sure your client, your buyer client knows when compensation is earned, okay? Make sure we are clear and educating our buyers on that. 4D goes on to say when compensation will be due and payable, and it's due and payable at distribution of proceeds from the sale of the property. So at closing, that's when it's due and payable, or upon buyer's default of any purchase agreement. So if the buyer defaults, technically the firm has earned compensation. Now it goes on to explain if buyer defaults, the total compensation that would have been due the firm will be due and payable immediately in cash from the buyer, okay? No assignment of rights in real property obtained for a buyer or any assignee of buyer or any person or legal entity acting on behalf of buyer pursuant to this agreement shall operate to defeat any affirmed rights under this agreement. So that 4D goes on or explains when compensation is due and payable, and that no one working on behalf of the buyer can defeat that, okay? All right. 4E, I won't get into this so much, but 4E talks about if there's any disputes and there happens to be attorney fees and costs, that whoever the prevailing party is, or if the firm is the prevailing party, then we will seek those fees to recover those fees from the buyer, okay? All right, 4F talks about if the buyer is purchasing unimproved property, the agent may assist buyer in identifying a contractor to make improvements on the property, subject to the provisions of paragraph 10 below. It goes on to say that buyer acknowledges and understands that in such a case, the contractor may offer to compensate the agent, and the agent shall disclose to buyer the existence of such an offer of compensation before the buyer enters into a contract with the contractor, okay? So if the buyer's just purchasing land and you, the agent, help to find a contractor, that contractor may be willing to pay you as well, in addition to the commission earned on the sale of the lot. All right. Any questions or comments or concerns on the firm's compensation? We just really need to make sure that as buyer's agents, our buyer clients know when compensation is earned and when it's due. All right, paragraph 5, make sure our clients, buyer clients, are aware that there are other potential buyers looking at the same properties they are viewing. Okay, let me stop right there. I see a comment in the chat. Let me just read it here. I have a potential client that I just started talking to and has not yet signed buyer agency, but they just decided to wait until they file their 2020 tax return in order to try to qualify, okay, for a bigger loan. Do I still have them sign exclusive buyer agency agreement? And what should I put as the end date of that agreement? Very good question. And yes, I am of the opinion that yes, you go ahead and get them under buyer agency. I've had buyer agency agreements with people who couldn't even qualify yet, but I put them under buyer agency. I kept in contact with them. I explained how it works, and I would do it for a year whenever they thought they would be buying. So that end date doesn't have to be 3 months, 6 months. It can be as long as necessary to help the buyer potentially get qualified and then find the property and close on it. So yes, you can do that. Has anyone else had that situation and have anything they would like to offer or suggest?
I have.
Okay.
I've had a buyer that they're under buyer agency. They're under the agreement. They're not moving to North Carolina until January, but she still wants me to research and do things here and there for them, and I pretty much just said to protect her information.
Yes.
This is the best way to do this.
Exactly.
So, and anything can change from now till January. They might want to move in December.
Right.
So I just leave it open to, because I know things happen in that time frame. So I'd like to know that I'm under agreement so we can always move to the next step, and she's protected the entire time.
I love that, Tara. I love that. And I love that you said protect her information. Love that, because if you're not under exclusive, guess what? If they decide someone else, you can share. You got personal and confidential information about them and motivating information, and you can share that, especially if you were to obtain a listing that is something that that buyer is looking for. So I love that. Love that. Another thing, what I heard you say, what I took out of that is, and it's something that I like to do as well, is for me to really work for you and on your behalf, you need to hire me. And the way you do that is through this exclusive buyer agency agreement. So I love it. Thank you for sharing that, Tara. Anybody else?
Could I ask another generic buyer agency question?
Sure, absolutely.
So I actually have a client under agency, and they want to see like a for sale by owner that they found. How do you go about that as far as getting, like, obviously they don't have MOG or, lead-based paint or property disclosures, all that. How do you tackle that when you're representing a buyer who wants to see those type of properties?
Very good question, Jeff. And that, you know what, that happens a lot. So thank you so much for asking that and bringing that up. It goes back to what we saw yesterday in the working with real estate agents disclosure for listings, and that last box that says unrepresented seller. So of course you're going to disclose that seller because you're going to have to start, you possibly may have to start working with them. So you want to disclose them because you want them to understand agency and how it works, and that you are working specifically for your buyer. And as you're working with your buyer, you need to make sure, because you're the professional and you're the expert in the field, you're a real estate agent, so you know certain things that have to be in place in order to consummate or for that seller to convey the property. That being the Residential Property Owner Association disclosure statement and the mineral, oil, and gas rights disclosure. So because you are the professional, you can now educate the seller and let them know that these things are required in order for them to sell. North Carolina says that it's just not a real estate agent thing. It's North Carolina general statute that says every property needs to have those documents. So you can actually help the seller, and the seller may even see a benefit, you know, that you help them get their house sold. So you just approach it that way. Does that help, Jeff?
It does, thank you. Yeah,
Okay.
like I said, I just want to get those documents for my client, and like I said, I'm not representing them, so I can care less about them, but I need to protect my client.
That's right. That's right. Yep. You have to protect your client, and you follow the rules, and the rules say they are required. And most sellers, FSBOs, do not know that or not aware of those documents needed. Very good question. Okay. Other potential buyers, just to reiterate, help your buyer understand that there are other buyers looking for the same property, and that your firm may potentially have other buyers looking at the same property as well. Okay. 6 firms' duties is wrapped up in Old Card. I won't go through that. We all know that from pre-licensing: obedience to loyalty, disclosure, confidentiality, accountability, or accounting, and reasonable skill, care, and diligence. That's what we owe them. Okay. 7 discusses disclosure of buyer's name and mailing address, information that may be needed about the buyer to give to lenders, attorneys, and third-party vendors, making sure they are aware of that. Okay. Paragraph 8 is the non-discriminatory language that is included in all of our agency agreements. Make sure that your client is aware that once they sign buyer agency agreement, that they know we cannot discriminate. Even if they discriminate, that's calls for termination of agency, because that's something we cannot do. We are prohibited from doing. It's federal and state law. Okay. The warning box here, outlined in red, discusses or talks about buyers' letters to sellers. This is important because buyers are using this, and there are some agents who are instructing their buyers to use love letters to the seller to somewhat plead their case on why, or make their offer stand out, right? But plead their case as to why their offer is better, or why the property would be great for them. Sometimes where their offer should be chosen. Let's be very careful of that. And I must read this warning box, and it says, personal letters to sellers expressing why a buyer wishes to purchase a seller's property is a tactic sometimes used to attempt to make a buyer's offer stand out to the seller. Such letters often contain personal information and reveal characteristics of the buyer, which could be used knowingly or through unconscious bias as a basis for the seller's decision to accept or reject an offer that may violate state and federal fair housing laws. In order to avoid potential liability for unlawful discrimination, as well as the appearance of impropriety, buyers should discuss with firm how any such letters will be handled. So make sure that we are discussing this up front or at the time of an offer if a buyer decides they want to submit a letter. Let's be very careful of that. The other thing that can happen is if the buyer emails the letter to us, we can read it, and we may have an unconscious bias because of what is said in the letter. Not saying that we would, but it possibly could happen. So let's be very careful of that. For me, I've had that happen, and I'm sure some of you may have had that happen in the past, where a buyer gives a letter and they email it. I had the listing, and an agent emailed the document, the buyer's letter, to me, as well as put some of the information in the email along with the offer. Now, I couldn't help but to read it in the email, but I certainly did not open the letter. I asked my seller client, how would you like this? Would you like to receive it, number one? And if you do, I told them I don't want to be privy to it. I will choose not to read it. However, I follow their lawful instructions on if they want to receive it. And my sellers chose not to receive the letter. So just be careful with that and make sure that there's no, it can't be said or give an appearance of discriminatory practices.
Teresa, I have a question about about letters.
Yes.
So much digital communication, excuse me, when it comes to sending information.
Uh-huh.
I know that it's possible to send documents with, say, a password. So maybe that's a way to send that particular document. If your clients really want to send something like that, then encourage them to maybe send it with a password protected, so that if the sellers choose to read it, then you provide them the password so that you're kind of left out of it. Maybe that's because I mean, putting it in an envelope seems so.
Antiquated.
Yeah. But the last time I got anything in writing in terms of paper on a contract stuff was never.
Yeah, right. Exactly. You're absolutely right. And yeah, that's a good point, Ethiel. There are ways to send those things, electronically. I like the password protected if the seller so chooses to open it up. I like that. Yeah, that's a great way to handle that. Absolutely.
Like if somebody really wanted to do that, how do you do it? Well, I use Adobe Professional, which you can make a password for.
Right. I love it. Love it. And yeah, technology is so vast today. There are ways to get that done. Great point and great strategy as well. I like it. Like it. Thank you for sharing that. Very good. Okay. If no other comments on the buyer letters, we'll move on to paragraph 9, which is buyer's duties. Make sure that the buyer is aware of their duties. I won't read them here, but please take the time to do so. Okay. 10, paragraph 10, other professional advice. We are real estate agents. We are not inspectors and attorneys. We are not appraisers. So make sure, although we may refer a vendor to the client, we have no liability in what that vendor does, okay? And if they need other professional advice, we are to refer them or just have them go seek that vendor out themselves, okay? Make sure we stay in our lanes. All right, we are to make sure that we provide our clients with sample copies of the offer to purchase, sample copy of the professional services disclosure, and a copy of the questions and answers on home inspections brochure. And I will say this, let's also make sure we are just not checking the boxes, that we are actually providing these sample copies. And maybe you have a or a buyer consultation packet or electronic packet or actual physical hard copy packet, whichever way. Let's just make sure that we are actually providing these documents to them. All right, paragraph 11, home warranty. It says that the seller of any property buyer may be interested in may or may not provide a home warranty. If the seller doesn't, then we as buyer's agent or as a firm may have a warranty company that we recommend or refer to them. And if we do, we have to disclose to them if the warranty company will provide a referral fee to the firm. If the warranty company does, we have to disclose that. And here is where we would do that. Okay, if that is the case, and I don't think we have anybody as a firm who, or any warranty company that is providing a referral fee to us. So I know as a firm, that would be zero. However, if you, the agent, has developed a relationship with different vendors out there in hopes of being of better service to your clients, and if that's the case and you get a referral fee from the warranty company, just put that there. That way we can make sure we are disclosing any additional compensation to the buyer, okay? Paragraph 12, confidentiality of offers. We're prohibited by the North Carolina Real Estate Commission from disclosing the price or any other material terms contained in our the party's offer, okay? We cannot do that. And as buyer's agents, we should not be asking listing agents to provide terms of offers that they've received as well, okay? So let's make sure our clients know that we follow the rules and we keep the terms of their offer confidential. All right. Paragraph 13. Here is where we would include any additional provisions not contained in this agency agreement. And as an example here, we just put in here, buyer must have a property with a dog run for their 7 dogs, okay? If the buyer is looking for that and that's a provision they'd like to include, we would put that here, okay? So those additional provisions can be a myriad of things. That can be anything that the buyer or you as a buyer's agent want to include and make sure your buyer is aware of, then put that there, okay? Paragraph 14, dual agency. Dual agency, we need to make sure it is explained to our buyer client. So when it comes to dual agency, it explains in 14A how information is disclosed or not disclosed, depending on the situation. 14B talks about the firm's role as a dual agent. And 14C talks about the buyer's role as in a dual agency situation. I will not read each one of these, but I encourage you to make sure we are clear on dual agency and clear on designated agency, when it arises and when and if the buyer chooses it. And they do so in 14D by authorizing you and the firm to operate as a dual agency. They can choose that. If they do, they check, or not check, initial the top box. If they do not, if they desire exclusive representation at all times, they would initial the second line there, or the second paragraph. However, make sure they know if they desire exclusive representation, then they cannot see any listings that the firm has, okay? So it would behoove them to initial the top line or authorize dual agency. Now, if they authorize dual agency, but they want you, the agent, to be exclusive to them or designated to them, then they would also, in addition to dual agency, the top line, they would authorize designated as well. Now, here's the thing. We prefer, as a part of our policies and procedures as a firm, we prefer all agents to be dual and designated. That's our preference, okay? So just so you'll know that. There's a note I'd like to read about dual agency here in the blue box. And it says, when dual agency arises, an individual agent shall not practice designated agency and shall remain a dual agent if the individual agent has actually received confidential information concerning a seller client of the firm in connection with the transaction, or if designated agency is otherwise prohibited by law, okay? So just make sure that we are aware of that in the case dual agency arises. which is why we like designated from the very beginning, okay, as a firm. All right, continuing on, 14F, dual agency compensation. If the firm acts as a dual agent, then the total fee the firm expects to receive for its services is 6%, because that's our policy, 6% of the contract sales price, okay? All right, so that would go there. Paragraph 15 talks about mediation. I won't read that. However, we are agreeing with the buyer and the buyer with the firm to mediate if there are any issues or concerns that arise out of this agency agreement, okay? 16 talks about entire agreement. If there's any changes or terminations, it needs to be in writing, and make sure you're just clear on that. I won't go through that particular paragraph. 17 speaks to surveillance, just understanding that as we're showing properties and viewing properties, there could be video and audio and surveillance equipment or devices, and we are to be aware of that, okay? Photographs and video. I will just read a couple of lines here that says, unless a property owner has notified the public that photography and video recording is prohibited, it is permissible to photograph or video the interior of private property, okay? Since the owner's permission to enter the property implies permission to do so. All right, so I know that happens a lot lately, especially in the market that we've been in. Buyers want to photograph or video because maybe another party couldn't be there. So that is okay to do unless the seller has made it known or the listing agent has made it known not to do so, okay? Paragraph 19 discusses wire fraud. This is a big one, and it is happening a lot over the past few years. So make sure we're educating our buyer clients to not send wiring information through email electronically unless it's protected, and I would still be very leery of that. Sometimes an attorney may send things that are encrypted, or they have a specific, type of app or encryption that they include. Be very careful. I always tell my buyers, clients, and sellers as well to contact the attorney directly. I also instruct them to never give me their wiring instructions, never to email or to send that way. So make sure that they read this paragraph and are aware, okay? And this brings us to the end of the buyer agency agreement. Make sure we include our buyer's information as well as our information, okay? Any questions on completing buyer agency agreement? Or just any questions in general on the buyer side? Okay. All right, very good. The last thing that I want to talk about is the heritage disclosure and selection form. Those are located in Command, okay? On the DocuSign side, I am going to bring those up. Heritage title was, let's see, those forms were sent out, I believe, earlier this year, but we have uploaded them into Command. Just give me 1 second here to open it up. Okay. Selection. Here we go. Okay, here is the heritage affiliated business arrangement disclosure. Now, let me explain this particular form. This is simply the disclosure. RESPA, which is the Real Estate Settlement Procedures Act, requires that anytime our market center has any type of business relationship with a vendor where we can potentially make money from it, we have to disclose that to our clients. So especially because this relates to buyers, this is something that is required on the buyer side in our transactions. So we must disclose to every buyer that we have a business relationship with Heritage Title and that we have this title insurance available. And if they choose it, we will be, as a firm, compensated from it, okay? But I want to make sure that we're clear about this. And it says, middle of the page here, you are not required to use Heritage Title or Investors Title Insurance Company as a condition for settlement of your transaction on the subject property, okay? Let's make sure that as we're getting our buyers acknowledgement that we told them we have a business relationship, let's make sure they are clear that they are not required to use it. It is now two forms. We have a disclosure form and a selection form. There used to be only one form and it was not very clear, so we had Heritage to change it. So this is just merely the buyers acknowledging that we told them we have a business relationship with Heritage. You're not required to use it. We just have to tell you to follow federal laws, RESPA, okay? So make sure that's included. Make sure you get your buyers to sign it or acknowledge it. Now, maybe a best practice is to have the buyer sign this disclosure at the time they sign exclusive buyer agency agreement. That's typically the best time to get it done. Just say, hey, letting you know we are partnered with a title insurance company. You don't have to use it, but we have to disclose it to you, okay? So that is the disclosure. Now, at the time of offer, we can ask the buyers again, would they like to use Heritage Title? Now, if they do, and give me 1 second, I'm gonna open it up. If they do decide to use Heritage Title, that's not the right one. Hang on 1 second. Let me open it. Bear with me 1 moment. That's the disclosure. Okay. No, that's the disclosure. That's not the one I want. I'm sorry, I got these not titled. Is there a question there in the chat? Yes, Nicole. We do need to give this to all buyers. We are to disclose all buyers. Let all buyers know that we have this business arrangement. Yes. However, it's not required that they use it. And just forgive me, I have so many windows open on my desktops here. That's the disclosure. I'm just trying to find the Heritage Title selection. There it is. Let me put that over there. Okay. Oh, I have so many windows open. Confusing. All right, can everyone see the desktop there? If someone could just give me a thumbs up or
Yes.
Yes, fabulous. Thank you. Okay, so this is the selection form. Again, a buyer does not have to select or elect to use heritage title. However, if they do, this is the form. It's different from what we saw earlier. So a best practice may be to have or to review this again at the time of offer or once there's a contract. Once there's a contract, say, hey, buyer, would you like to use? We disclosed to you earlier that we have a relationship with Heritage Title. You will, especially if you're getting a loan, are required to obtain title insurance. And we enjoy being a one-stop shop or providing as many services as we can to you. Would you like to use Heritage Title? If they say yes, this is the form, okay? And it simply has the buyer's name, the particular property address that they are under contract for. And section 3 here is where they will choose if they would like to use Heritage Title, okay? If they do that, check the box. They can do that. And they simply sign, put their information there, and you, the agent, sign as well, okay? Again, they do not have to select Heritage Title. However, we do have to disclose to them that we have a business relationship with them. Okay. Any questions here? No questions? All right. Well, let me see if I've covered everything that we needed to cover in this particular boot camp. Just going to my slides here. All right, so we've talked about the Working with Real Estate Agents brochure for buyers. We've also discussed and reviewed the exclusive buyer agency agreement and what we as a firm like to see in the blanks. And we have discussed Heritage Title. Okay, that is all for Boot Camp 2, Camp 2, Buyer Agency. Oh, one other thing I do want to mention up with Heritage Title. If your buyer client does select Heritage Title, make sure you get that to the attorney, the closing attorney. When they sign this form, you sign it, forward it on to the closing attorney. That way the attorney knows that the buyer is selecting to use Heritage Title, and they can then start the communication with Heritage at that point. Okay. Any questions, comments, anything there?
I do have a couple of questions about the buyer agreement.
Yes, ma'am.
So in terms of retainer fee,
Yes.
I've never dealt with a retainer fee.
Okay.
Is that something that we should learn more about, or how would you go about discuss? I mean, because, you know, it's nice to have some money.
Absolutely. You're right. You're right. Yeah, so I do believe, Ethios, great question. I do believe that we all should learn more about retainer fees and how to apply them and how to possibly incorporate them into our business. And the reason why I say that is because for several reasons. I in my former office in Chapel Hill, there was a very successful agent doing lots of business, top producing agent. That was part of her business. She charged a retainer fee. And not only did she check the box for the retainer fee, and I want to say it was like $500 that she charged, and sometimes more than that. She charged that as a retainer fee. And she also put in She also included some language in the additional provisions section of the buyer agency agreement to spell out how that would be applied, when it would be applied, if it would be applied. So she was very successful with it, and buyers actually paid it up front. She incorporated it well into her business. There is another agent that uses or charges a retainer fee. And the reason why, and I believe that particular agent had a tiered retainer fee. And they charged a smaller amount depending on the length of the agency agreement. The longer the agency agreement, the higher the retainer fee. So that particular agent incorporated it in their business for that, depending as a tiered option. If the agency agreement is 3 months, $100, 6 months, 5, a year, whatever it was, that's how they use it. So I do believe it's worth, especially in this market that we've seen where we're doing a lot of work as a buyer's agent, and sometimes it's not fruitful. Writing so many offers, that's very time consuming. Writing an offer, getting the information, running CMAs, that's a lot. So yeah, I think it's worth researching and thinking about it and seeing how each agent could incorporate it and possibly try it out. We addressed it in policies and procedures that if the retainer fee is a certain amount, we won't even take company dollar, no splits from it. So I think it's worth it, definitely.
I think it could especially be beneficial, especially even when you're first starting out, you lead with revenue and you got to put gas in your car to drive all over tarnation.
That's right. Ethiel, that's a very good point. Very good point. As a new agent, you're right. Because you spent so much money, you invested in your business, MLS, all of these fees that we kicked out, and it may be a while, months before an actual closing. Good point.
You could also see how people value what they pay for. So if you're paying something, and also as a person receiving some compensation, you see like, I'm definitely going to get something. So you're going to work a little harder, maybe when you want to sleep a little extra. Maybe that like, hey, I got to get it because I've already been paid. And people do value what they pay for.
They do. When I hear people say, my services are free to buyers. Well, it's not really free to buyers, because technically, if we're not seeking or if we don't get compensation from the listing or seller side, then we expect it from the buyer. And I don't believe that's something we shouldn't put it that way. It's free to you because time is investment as well. I agree with you.
Somebody.
That's right. Exactly. Yeah. So I actually believe it's worth, and maybe you don't, depending on how each agent runs their business, maybe it's not something you do all the time. Maybe you try it here for this situation, or, I don't know. But yeah, it's worth looking into. Definitely. Okay. A couple of things in the chat here. Yes, Kinsey, the Zoom call was recorded yesterday. I will get with Jen and or Jonathan to make sure it gets out. Second question, does the retainer fee ensure that you get some money out of the relationship if they decide to terminate? Absolutely. And maybe that's something that can be included in that additional provisions section of the exclusive buyer agency agreement. If buyer you terminate, then retainer fee remains with me. If you don't if you continue to use me or whatever, then I'll give you credit for it.
If I fire you, you can have it back.
Right, exactly. Right. If I terminate, I don't have a problem with parting with your money. So, or parting with it. So yeah.
also want to add to that, that's the retainer fee for me is good for out-of-state clients, because you're doing the runaround yourself. And I just learned my lesson on that, because I did have an out-of-state client, and I went and I did research, and I went and I saw property. And then he decided, because the property needed work, a lot of work done to it, that he would not. And I already did the runaround. And I just learned about the retainer fee also on Saturday during our coaching session. So I find that would be a definite for out of town, especially out of town clients, that you basically have to do all the work for them.
Right.
And they can cancel at any time, just like mine did. And so I find that to be, a plus for us, that, maybe they'll take it more seriously when they're working with us.
I love it, Ruth. Absolutely. And that's the thing. They need to realize this is our job. This is what we do. I love that, Ruth. Charging the retainer fee for out-of-state buyers. Yes. Love it. Love it. Love it. Yeah. So definitely think about how it can be incorporated into your business, and frame it however it works for you and works for your business. I love it. Love it. Love it. Very good. Any other comments?
So what's best practice for the number of days after expiration of the buyer agency agreement? For the number, I mean, they can be 30 or 300. I've seen them kind of all over the place.
Yeah. I think it's up to the individual agent, how they run their business. But I will say, for me, I'm a person where it's somewhere between 60 to 90 for me. Out any shorter than that, for me, less than 60 says that things are still fresh on the buyer's brain and in my brain, and so, yeah, they could kind of double back to do something. So I think right around that 60, 90 day time frame for a protection period, they're probably less likely to do something in that time frame. And that's just me. That's my personal opinion and view of it. Anything more than that, I'm probably going to forget about something. So I don't know that, do I want to make somebody be tied to me for that long if the agency expired or something? I don't know. Hopefully it never expires. Hopefully the job is done during the time of the agreement. So, and that's my mindset as well. I don't want this to expire. We're not expiring. We're going to get this job done.
Maybe that's what the retainer fee does, is makes you work.
Yeah, right. Exactly. There you go. Exactly. I see another question here in the chat. How do you collect the retainer fee? What if they refuse to pay it? Good question, especially that second one. How do we collect? It can be check, money order, however you can receive it. Of course, it needs to go to the firm. It needs, if it's a check, of course, or money order or cashier's check, it needs to be written to the firm, because commission rules says now we cannot be paid by anyone except for the BIC or the firm. So it's written to the firm then writes the check or however it's going to be to you. What if they refuse to pay it? Great question. That's going to go back to how we do our business, how we run our business. If they refuse to pay it, is there my question is this: if they refuse to pay it, if retainer fee is how you're really running your business, do you want to do business with them? Maybe you refer them out to someone else and collect and still get paid from it, collect referral fee, which is going to be more than your retainer. So do you want to work with someone that refuses to pay? If you do work with them and they refuse to pay it, then what other incentive is there, or what other thing is there to help them remain in buyer agency agreement with you if the retainer fee is not there? So yeah, I consider that. If they don't, do I want to work with you? Can I refer you out and still get paid? Good questions. Good questions. All right. Well, if no other questions, that's all the information that we wanted to get out on the buyer side. I will say this, please, please, please. This is the first time we've done boot camp and that we've incorporated it into our not only new agent, but agent information and education. We want all of the feedback, constructive feedback. How can we make this better? Something that we can include. I know this is only day 2, but we have 4 days to go. Tomorrow, we'll be talking about the offer to purchase and contract. We'll talk about contracts and common addenda that we see today. So we'll be talking about that aspect tomorrow. Thursday, we'll be discussing policies and procedures. So we'll know how to work all of this within the rules of our particular market center. Again, feedback, feedback, feedback. What can we add to this? How can we make it better? We're always looking for great ways and good ways to improve. Any other questions or comments or before we wrap up? Don't forget, team meeting is at noon today.
I would like to say, so I've been practicing since 2015, and this is really valuable, especially to hear it from our broker in charge about how the contracts should be written and what do you fill out in the blanks.
Okay.
And it's a very good way for us to all be on the same page. And I truly would love to see many more of us kind of go through this. What do you put in the blanks?
Right, exactly.
And it protects the firm.
Yes.
I mean,
thank you, Ethiel. I appreciate that. We are thinking of better, how can we get this out there? Even, I know we're across 3 locations. However, we are one big market center. And I want to make sure we are serving, especially in the staff and in leadership, I want to make sure we're serving all of our agents. So if there's something, thank you for that, Ethiel. If there's something you feel we should add or include or incorporate or do better, please, 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 please let me know. I'm just reading the chat here. This was, okay. Most information maybe. Okay, well, awesome. Thanks, Kenzie. Glad this could be of benefit to you. A place for everyone to find and review. Hard for delayed during the day. Yes. I'm glad you were able to attend, Sean. Don't forget, these are recorded, so we'll get these out to everyone. Also, I sent out the information through zip files. I believe it was this morning. The actual documents, the examples of how to fill in the blanks. If you were not here yesterday and you would like to receive that packet, please put your email in the chat and I will get it out to you. It includes all of the forms, listing, buyer, heritage title, the guidelines to completing the forms, all of that. If you would like that, put your email in the chat and I'll get it to you. Awesome, awesome, awesome. All right, make sure I get it to you. Outside of that, I'm done. That's the information we had for today. We'll be talking about the offer purchase. Whew, that's a big one, right? The offer to purchase and common addenda that we see today. So if you're interested in that, join us back here tomorrow at 10. Don't forget team meeting at noon. All right. Thank you, everybody. Thank you all for coming. Hope to see you tomorrow.